I have presided over thousands of disputes involving neighbors, contracts, businesses, and families. But one case still stands apart because a homeowner looked directly at the bench and confidently declared, "Those HOA rules don't apply to me." She repeated it under oath without the slightest hesitation. What she didn't realize was that, resting inside the case file before me, was the very document she had personally signed years earlier. The moment I held it up, the entire courtroom seemed to stop breathing. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. My name is Judge Judith Harper. After decades on the bench, I've learned that many lawsuits are never really about fences, driveways, landscaping, or parking spaces. They're about promises. Promises people make when everything is going well. Promises they later pretend never existed. The plaintiff was Karen Mitchell, a 48-year-old homeowner who had lived in the Willow Creek Estates community for nearly 6 years. She described herself as an independent thinker, someone who refused to let petty neighborhood politics dictate how she lived. The defendant was the Willow Creek Homeowners Association, represented by its board president, Daniel Harper, along with the association's attorney. Their position was straightforward. Karen had repeatedly violated community rules regarding exterior modifications, unauthorized fencing, and commercial equipment stored in plain view. After months of warnings, fines, and formal notices, the association sought enforcement through the court. Karen insisted the HOA had no authority over her property. She claimed the rules had been changed without her knowledge. She repeatedly stated that she had never agreed to the restrictions now being enforced. She delivered those statements with remarkable confidence. Confidence, however, has never been evidence. As opening testimony began, Karen described the HOA as controlling, unreasonable, and determined to target her personally. According to her, every citation she received was retaliation because she had challenged the board during neighborhood meetings. The jury listened carefully. So did I. Then Daniel Harper quietly organized several folders on the defense table. He never interrupted, never reacted. He simply waited. That immediately caught my attention. Years of judicial experience have taught me that people who possess strong documentary evidence rarely feel the need to argue before presenting it. Karen continued speaking. She insisted she had searched every closing document from when she purchased the house. She testified that no binding HOA agreement had ever been presented to her. She even looked toward the jury and said, "If someone thinks I signed those rules, I'd like them to prove it." The courtroom grew noticeably quieter, not because of what she said, because of how calmly the defense attorney stood after hearing it. He didn't carry a stack of binders. He carried a single file, thin, neatly organized. He requested permission to introduce Defense Exhibit 4. I granted the request. Karen smiled. She appeared completely certain that nothing inside that file could contradict her testimony. But as the exhibit was handed to the clerk and placed before me, I immediately recognized the document. I had seen hundreds like it throughout my career, a standard acknowledgement signed during the purchase of a home within a homeowners association. I glanced down once, then back toward Karen. She had no idea what I was holding, and within moments, the very signature she claimed never existed would become the centerpiece of the entire trial. The second day of trial began with an atmosphere unlike the first. The confidence Karen Mitchell had displayed during her opening testimony remained, but the courtroom had changed. The jury now understood that documents, not opinions, would likely determine the outcome of this case. Years on the bench have taught me that neighborhood disputes often become intensely personal. People stop arguing about property. They begin arguing about pride. Karen entered the courtroom carrying several folders of her own. She placed them on the counsel table with noticeable confidence. Daniel Harper arrived carrying the same thin file he had brought the previous day. Nothing more. That interested me. Strong cases often become simpler as they unfold. The defense attorney requested permission to continue cross-examination. I granted it. He approached the witness stand with Defense Exhibit 4 in his hand. Ems. "Mitchell," he began, "yesterday you testified that you never agreed to be bound by the HOA's governing rules. Is that still your testimony today?" Karen answered immediately, "Absolutely. No one ever had me sign anything." Her response was firm, unequivocal. The attorney nodded politely. He didn't argue. He simply placed the first page of Defense Exhibit 4 onto the courtroom display. It was a standard property closing acknowledgement, nothing dramatic. Just several paragraphs outlining documents provided to the purchaser at closing. The attorney asked another simple question. Do you recognize this document? Karen leaned forward. She studied it for several seconds. It looks like closing paperwork. Is your name printed at the top? Yes. And is this the closing date for your home purchase? Karen hesitated. Yes. The attorney thanked her. Then he enlarged the bottom portion of the page. A signature appeared. The courtroom remained silent. Ms. Mitchell, he asked, whose signature is that? Karen looked at it carefully, then answered quietly. It appears to be mine. Appears an interesting choice of words. Years of experience have taught me that when people shift from certainty to cautious language, something significant is usually happening, the attorney continued. Did you sign this document during your home closing? I signed a lot of papers that day. Again, not quite an answer. He repeated the question. Did you sign this one? After a long pause, Karen finally answered. Yes. Several jurors immediately made notes. One looked directly at Karen instead of the exhibit. Another slowly reread the document on the monitor. The defense attorney wasn't finished. He turned the page. Attached to the acknowledgement was a checklist prepared by the title company. Each item represented documents provided to the buyer before closing, property survey, warranty deed, mortgage disclosures, insurance information, and one line highlighted in yellow. Homeowners Association declaration, covenants, conditions, and restrictions received by purchaser. Beside that line was a set of handwritten initials. The attorney looked toward Karen. Ms. Mitchell, whose initials are these? Karen didn't answer immediately. She stared at the screen. The confidence that had defined her testimony began to fade. Finally, she spoke. They're mine. The courtroom remained perfectly still. The attorney said nothing for several moments. He understood that silence often carries tremendous weight. Then he introduced one final document, not the HOA rules themselves, not yet. Instead, he placed an acknowledgement receipt onto the projector. Across the top were the words, receipt of governing documents. Kara's expression changed instantly, because she recognized it. And I recognized something else. The page wasn't merely signed. It contained a handwritten sentence that Karen herself had written at the closing table, a sentence she had completely forgotten. One that would make denying the HOA rules almost impossible. And before this trial was over, I would hold that very page up for the entire courtroom to see. The third day of trial began with an unusual sense of anticipation. The previous afternoon had ended with the defense displaying a receipt acknowledging the HOA governing documents, but one sentence on that receipt had remained unread. That was intentional. Experienced attorneys understand that timing matters. Sometimes the strongest evidence is introduced one step at a time. Karen Mitchells entered the courtroom noticeably quieter than she had been during the first 2 days. She no longer smiled toward the gallery. She avoided looking at the evidence screen. Daniel Harper remained composed. His demeanor had not changed since the case began. That consistency caught my attention. Years on the bench have taught me that people who trust their evidence rarely need to adjust their behavior. The defense attorney requested permission to continue. I granted it. He walked to the projector and displayed the acknowledgement receipt once again. This time the entire page appeared on the screen. The highlighted sentence sat near the bottom, handwritten, signed. Dated. The attorney looked at Karen. Ems. Mitchell, would you please read the handwritten statement aloud? Karen stared at the monitor. She didn't speak. I waited. Silence has a purpose in a courtroom. It gives people the opportunity to answer honestly. Finally, Karen began reading. I acknowledge receiving a copy of the Homeowners Association Declaration and understand that ownership of this property is subject to its recorded covenants and restrictions. Her voice grew noticeably softer by the final words. The courtroom remained absolutely silent. The attorney asked one question. Did you write that sentence? Karen looked down. Yes, and immediately below it, is that your signature? Yes. Years on the bench have taught me that admissions given under oath often carry greater weight than arguments delivered with confidence. The defense attorney then displayed another exhibit. A copy of the recorded HOA declaration filed with the county years before Karen purchased her home. It matched the acknowledgement receipt perfectly. Same document title, same recording number, same effective date. Nothing had been changed after she bought the property. That directly contradicted one of her central claims. Karen attempted to explain. She suggested the rules had probably been revised over the years. A reasonable possibility. The attorney nodded, then introduced certified amendment records from the county recorder's office. The amendments involved only administrative matters. None affected the restrictions at issue in the lawsuit, the fence requirements. The exterior storage rules, the architectural approval process, all had existed before Karen purchased her home, exactly as they appeared in the packet she admitted receiving. I watched the jury carefully. Several members compared dates. One juror slowly traced the timeline with a finger across the exhibits. They were assembling the story themselves. That is always more persuasive than having someone assemble it for them. Then Karen became visibly frustrated. She shook her head repeatedly. "This is ridiculous," she muttered. The words were quiet, but everyone heard them. She insisted the paperwork had been buried among dozens of closing documents. She claimed no one had actually explained the HOA rules to her. Perhaps that was true. Perhaps no one had walked through every page. But there is a significant difference between saying no one explained them and saying I never received them. One concerns understanding, the other concerns possession. Those are not the same. As I looked down at the signed acknowledgement resting in front of me, I realized the case was approaching its defining moment. Because Karen had now admitted writing the sentence, admitted signing the receipt, admitted receiving the governing documents. Yet she continued insisting the HOA had no authority over her property. Within hours, that contradiction would become impossible to maintain. And when I finally lifted the signed document for the entire courtroom to see, every remaining doubt would disappear. The fourth day of trial is the one I remember most vividly. Not because someone shouted, not because anyone stormed out of the courtroom, because it was the day the difference between opinion and proof became impossible to ignore. Karen Mitchell arrived looking determined. She still believed she could explain away the documents. I've seen that before. When people become emotionally invested in a position, they sometimes convince themselves that persistence can overcome evidence. It rarely does. The defense attorney concluded his questioning and returned to counsel table. Then Karen's attorney attempted to repair the damage. He suggested that signing paperwork during a home closing can be overwhelming. I agreed with that general principle. Anyone who has purchased a home knows the stack of documents can seem endless, but being overwhelmed is not the same as never receiving the documents. That distinction remains central to the case. Karen took the opportunity to address the jury again. She insisted she had trusted the professionals handling the closing. She claimed she had no realistic opportunity to understand every page. She argued that the HOA should have personally explained every rule after she moved into the neighborhood. Those arguments focused on fairness. The lawsuit, however, focused on notice. They are related, but they are not identical. Years on the bench have taught me that courts must decide cases based on legal obligations, not simply emotional impressions. Then came the moment I knew would define the trial. The defense attorney asked permission to approach the bench. He handed me the original acknowledgement document, not a copy. The original, the ink signatures were clearly visible. The initials matched every other document in the closing file. I examined it carefully. Then I looked toward Karen. She watched me, uncertain. Perhaps she believed I was reviewing a technical detail. Instead, I slowly raised the document so the jury could see it. The courtroom became completely silent. I held it high enough that everyone had an unobstructed view. Then I asked one question. "Ms. Mitchell, do you recognize this document?" She nodded. "Yes, this is the original acknowledgement you signed during your home purchase?" "Yes." "And the handwriting stating that you received and understood the HOA declaration?" I paused briefly. "Is yours?" Karen looked at the page, then quietly answered. "Yes." No one moved. No one spoke. I lowered the document back onto the bench. Years of judicial experience have taught me that sometimes a physical document carries a power no verbal argument can match. Paper does not become emotional. Ink does not exaggerate. Signatures do not develop new meanings simply because a dispute arises years later. Karen tried once more. She said she hadn't believed the rules would actually be enforced. That statement immediately caught my attention, because it was very different from saying she never agreed to them. Very different. Now she wasn't denying the rules existed. She was admitting she expected they wouldn't matter. The jury noticed that shift as well. I could see it in their expressions. One contradiction had become another. The case was changing before everyone's eyes. Then the defense attorney stood for one final round of questioning. He carried no additional exhibits, no new documents. Only a single question that would expose the difference between what Karen claimed in court and what she had admitted years earlier. The answer to that question would leave the courtroom in stunned silence and bring this trial to the edge of its most unforgettable moment. The courtroom was so quiet that I could hear the faint rustle of legal pads as jurors adjusted their notes. No one expected another dramatic piece of evidence. The documents had already spoken. Karen Mitchell had acknowledged receiving the HOA declaration. She had admitted the signature was hers. She had admitted the handwritten statement was hers. Yet she continued insisting the association had no authority over her property. The defense attorney rose one final time. He carried nothing in his hands, no folders, no exhibits, just a legal pad. That immediately caught my attention. Years on the bench have taught me that when an attorney stops relying on documents, it is often because the documents have already done their work. He approached the witness stand. "Ms. Mitchell," he began calmly, "I'd like to ask you one final question." Karen nodded. "You testified that you believe the HOA rules didn't apply to you, correct?" "Yes." "And you've also admitted you received them before purchasing your home." Karen hesitated. "Yes." The attorney thanked her. Then he asked the question that changed the entire trial. "If you truly believed those rules didn't apply to you, why did you submit 3 architectural approval requests to the HOA during your first 2 years in the neighborhood?" Karen froze. The courtroom remained silent. I watched her expression carefully. Confusion, then surprise, then realization. The defense attorney walked to the evidence screen. 3 separate application forms appeared, one for a backyard patio, one for replacing exterior windows, one for installing decorative landscaping. Each application bore Karen's signature. Each requested approval from the HOA's Architectural Review Committee. Each had been approved. The dates were years before this lawsuit. The attorney spoke softly. "Ms. Mitchell, if you believed the HOA had no authority over your property, why did you ask for its permission 3 different times?" No one moved. Karen looked from one document to another, then toward her attorney, then back to the screen. Finally, she answered, I don't remember." Years on the bench have taught me that memory often fades. Records usually do not. The attorney displayed another document, an email Karen had personally written to the HOA board after her patio request was approved. It read, "Thank you for approving my application. I appreciate the quick response." Karen closed her eyes briefly. The contradiction had become undeniable. She had thanked the HOA for exercising the very authority she now claimed never existed. The jury immediately began writing. Several members compared the approval forms with the email. Everything aligned. The dates, the signatures, the correspondence. There was no missing piece. The defense attorney returned to counsel table. He asked no further questions. He didn't need to. The evidence had answered them all. As I looked across the courtroom, I realized something had fundamentally changed. This case was no longer about fences or landscaping or HOA regulations. It had become a lesson in consistency, because when someone's own words, signatures, applications, and emails all point in the same direction, denying the obvious becomes impossible. The jury had seen every document, heard every explanation, watched every contradiction unfold. Now only one task remained: to decide whether Karen's claims could survive the overwhelming weight of her own admissions. And before this trial came to an end, that decision would send a message every homeowner in the courtroom would remember for years. The final day of the trial arrived with an unmistakable sense of clarity, not certainty about the verdict. That belonged to the jury. But clarity about the facts. Every relevant document had been admitted. Every witness had testified. Every explanation had been offered. Now the case rested where it always should have rested, with the evidence. Karen Mitchell sat quietly beside her attorney. The determination she had shown during the first day of trial had faded into reflection. She no longer challenged every point. She no longer insisted the documents were meaningless. The weight of her own signatures, emails, and applications had become impossible to ignore. Daniel Harper remained composed. He had conducted himself the same way from the beginning, patinate, respectful, methodical. That consistency left an impression on me. The attorneys delivered their closing arguments. Karen's attorney urged the jury to focus on fairness. He argued that homeowners are often overwhelmed during the closing process and that many people sign documents without appreciating their long-term consequences. There was truth in that observation. Buying a home is one of the most complicated transactions many people will ever complete, but fairness cannot erase facts. The defense attorney stood next. He never raised his voice. He simply walked the jury through the timeline. Karen received the HOA declaration before closing. She acknowledged receiving it in her own handwriting. She signed the receipt. She purchased the property. Then, over the following years, she voluntarily submitted 3 separate architectural applications asking the HOA for permission to make improvements to her property. She thanked the board after receiving one of those approvals. Only after violations were cited did she begin claiming the HOA had no authority. The sequence spoke for itself. Years on the bench have taught me that timelines are remarkably powerful. People may disagree about opinions. Dates rarely argue. The jury retired to deliberate. The courtroom settled into quiet conversation. Karen stared at the table. Daniel reviewed a notebook, but never looked toward her. Several hours later, the clerk informed me that the jury had reached its verdict. Everyone returned. The foreperson stood. The verdict form was handed to me, then read aloud in open court. The jury found in favor of the Willow Creek Homeowners Association. Karen's claims were denied. The jury concluded that she had knowingly accepted the HOA's governing documents when she purchased her home and had repeatedly acknowledged the association's authority through her own conduct long before the dispute arose. Karen lowered her head. There was no outburst, no accusation. Only silence. Sometimes silence says more than any argument ever could. Before dismissing the parties, I offered one final reflection. I explained that homeowners associations are not above the law. Neither are they free to invent rules without authority. But homeowners also cannot ignore agreements they voluntarily accepted simply because those agreements later become inconvenient. Promises matter, especially written ones. Then I looked once more at the original acknowledgement I had held up during the trial. A single sheet of paper, one signature, one handwritten statement, nothing dramatic about its appearance, yet it carried more weight than hours of testimony. Because documents created before a dispute often reveal the truth more clearly than memories formed after one begins. As the courtroom emptied, I found myself thinking about Karen's first declaration. The HOA rules don't apply to me. By the end of the trial, the evidence had answered that claim more effectively than I ever could. Her own signature, her own handwriting, her own approval requests, her own thank you email, they all pointed to the same conclusion. After years on the bench, I have learned that people sometimes believe they can rewrite history simply by denying it. But history leaves records, signatures endure. And the truth has an extraordinary way of waiting patiently until someone is finally willing to look at it. That is why this case has remained with me, not because it involved an HOA, but because it reminded everyone in that courtroom that the strongest witness is often the one written in your own handwriting years before the lawsuit ever begins.